Okay, good evening, everyone, and welcome to the Wednesday evening online seminar with Silver Law. Tonight we are joined by Richard Silver, Senior Partner, and the latest in his construction essentials is what he will be talking about. So tonight's topic is adjudication. As always, if you have a question or query for Richard, please don't hesitate to use either the chat or the Q&A tool in the bottom toolbar there to ask away. However, if there is something that you would prefer not to ask in an open forum, but you would like his advice or thoughts on, please feel free to email him. You'll see his contact details there, richardsilver@silverllp.com. Okay, Richard, without any further ado, it's over to you.
Thanks, Julie. Good evening to you all. As Julie has indicated, I'm going to be covering what is my favourite topic, adjudication. Adjudication has been with us for some considerable time following the Construction Act. And I was trying to work out before the seminar how many adjudications I'd been involved with. And to say I've worked it out, it's over 1,000. I've been involved both as expert witness, representative for either the referring party or the responding party, and have been for many, many years and dealt with many disputes as adjudicator. So I am fortunate enough to be able to have an insight not only as the adjudicator who is being presented with the dispute and the submissions and has to reach his decision, but also have represented both a referring party and a responding party on many, many, many occasions. I'm going to address adjudication, the process, when it should not be used, the problems and difficulties. But the starting point seemed to me, is adjudication necessary? I am of the view that people often do not necessarily think about adjudication correctly. The first thing is the reason you're going to adjudication is because there is a dispute, quite obviously. But the point is why is there a dispute? Is it clear? Does the actual other side understand why you're in dispute with them? Who is the stumbling block? Is the threat of adjudication going to be enough? Do you actually have to go to adjudication? Or if indeed there is an adjudication, do you really want to warn the other side? Or do you want to do an attack without them being forewarned as much as you can? So my starting point is do look into whether adjudication is necessary. And if so, decide whether you want to first threaten adjudication or whether it is in your best interest not to threaten, but to go to straight away to adjudication. Because if you do threaten adjudication, it may assist in the resolution of the dispute without having going through the proceedings. Or alternatively, by threatening adjudication, what you may well find is the other party, now aware, tries to put in place all possible defences that maybe before they had not considered. I think the other point is, and I'll just raise this here because this is often something that a client will look at me strangely when I suggest this. When you're threatened with adjudication, the answer may be for you to take them to adjudication first. There are benefits of being the referring party, and I'm going to address this at the moment. But the point is once you've commenced the adjudication, effectively, the other party has a limited time. So if a party is putting forward this huge extension of time and you submit it and reject it, and then you go to adjudication saying they've got no further entitlement, because of the short period available to adjudication, they're only going to have 2 or 3 weeks to put more information together, by which time they may not have been able to meet, for example, cause and effect. So sometimes people don't recognise that actually adjudication is the correct forum and you should be commencing it as soon as possible. When you're dealing with adjudication, you have to consider what are the provisions under the contract. First and most obvious point is the contract may either provide for a named adjudicator or a nominating body or leave it open to the parties. It's my view that ideally, if you are putting the contract together, you should be stipulating who should be the adjudicator in your contract. so that you are not leaving it to the uncertainty of a nominating party appointing. You've got greater control. So there can be some benefits or arguments to say why you'd be better placed to place it in the contract. There are others who say, well, you know, the panel is much better placed. There are people with vast experience, and you don't know the dispute before you start. So therefore, you're better to putting a nominating body. One thing I think is very important is if you are going to put in a nominating body, ensure that that nominating body has people on that panel that have considerable experience of adjudication. There are many panels that have very few appointments, and those that on the panel therefore have very few appointments as adjudicator. As a consequence, they don't really understand the process. And I've found that on some less popular panels, the adjudicators, to be honest, have been terrible. The next point is what does the contract provide within the contract with regards to the process? For example, does it limit the amount of information that can be issued in the referral? That can obviously be a benefit where you stipulate that the referral shall be limited to, for example, 20 pages. Another one which I've seen, which is quite common, which can be of great assistance, is that you state that any document to be issued as part of the referral shall also be issued as part of the notice. No reason why you can't do that, with the fact that you get more time to look at what the referral is because you get it as part of the notice of adjudication. Now, the final thing, which I would suggest is the most common, more often than not, disputes are about money. And the person who wants money is the employed party, generally not the employing party. So under a main contract, it will most often be the main contractor. Under a subcontract, in my experience, it is more often likely to be the subcontractor. On that basis, the person placing the contract is most likely to be the responding party, and therefore it can be a great benefit to state that the responding party shall have 14 days in which to issue its response, rather than leaving it to the provisions that are expressed in the contracts. There's some contracts only provide for 7 days, and some contracts don't provide any date and leave it to the adjudicator. And it's not uncommon for the adjudicator to stipulate that the responding party only has 7 days. So recognize that in any construction contract you place, there is a potential that there is going to be an adjudication, and thereby put provisions in there that give you the best option of hopefully being successful in that adjudication. I do think it's important, and I know you'll all take this as me being biased, but it is important in my view that you know that the adjudicator has the necessary qualifications and experience to deal with the dispute. Now, let me just deal with that in a bit more detail. Let's say you're on a job and the job is going very poorly. It's being delayed. There are issues of defects in the works. There are differences as to the value of variation. The list goes on. This is a very, very difficult dispute, one that is common on construction projects. And you see that there is a chance that you may win or lose. What are you going to do in seeking to resolve this dispute? Are you going to seek legal advice? And if so, who are you going to seek this advice from? Now, I would suggest that in the main, when you find yourself in that nature of dispute, you're going to go and ask a construction lawyer. You're going to ask a lawyer who's going to look at the contract and say, what are the terms and what do they mean? And how are they to be applied? And what is the current case law on this? And what is the precedent, etc., etc., etc. So in my experience, in the main, when seeking advice, you go to a construction lawyer. So if you're then going to refer that dispute to adjudication, who do you want as an adjudicator? My suggestion is it should be a lawyer. I know I'm biased, but nearly every dispute I ever see has issues of law. They always have issues of jurisdiction and whether, and I'll deal with jurisdiction later on, whether the adjudicator can in fact deal with the dispute. And I would also suggest that 9 out of 10 adjudications I see, the parties are instructed lawyers to act as representatives on their part. And the lawyers are going to put all the legal arguments. So ideally, you want a lawyer as an adjudicator. Now, I would suggest if you are dealing with quantum issues, you should go for a lawyer with quantity surveying issues. Or if it's to do with delay, you might ask for a lawyer with a construction background who understands programming and planning. That's me, just in case you weren't sure. If you're dealing with architecture, then that's going to be a different area. You may well ask for a lawyer with architect background. But it is my view, and I do really emphasize this, it is my view that nearly all disputes relate to alleged breaches of contract and the interpretation of that contract. So I am a very strong believer that when seeking the appointment of an adjudicator, you should set down in the application the qualifications and experience that you expect of that adjudicator. Now, if you actually go to the RICS nomination forms, you will actually find in those forms an area where you can put down qualifications and experience of an adjudicator, and the RICS will seek to appoint an individual that meets with your requirements, as do other nominating bodies. As I've said, there may be a benefit of being either the referring party or the responding party. Now, being the responding party, the main benefit is that you can counterpunch. You can wait for the other side, in theory, to come out with their dispute, and then you can respond to it. There can be a great benefit in that. But equally, there can quite often be a substantial benefit in being the referring party, because you can set the scope of the dispute. You can identify what is the nature of dispute being as wide as you choose or as narrow as you choose. So let's just give you an example. Whether event 1 was an extension of time. Whether event 1 is or is not a relevant event. That could be as narrow as that. Or you could expand it to say whether it is a relevant event and what is the period of extensions of time that we're entitled to. Or you can go a step further and say, and is it a relevant matter? And then a further, if it is a relevant matter, what is our entitlement to loss and expense? Or even wider, insofar as we're entitled to an extension of time, we seek the release of liquidated damages that have wrongfully been withheld. You can see I can build up the dispute from what can be a very, very narrow item to a very, very wide dispute. And depending upon the circumstances, will dictate which one I want to do. Some can be a very quick and easy way of getting rid of a dispute, either in proving a point that leads to money or undermines another party's claim. But as referring party, it is up to me to be able to determine what I want to do. And I'm just going to give you an example. I have recently been involved in a dispute, and most of the cases I'm going to try and deal with are actual cases that are either quoted cases, and hence I'll give you the names, or ones that I've dealt with which have not gone to any form of enforcement. But I've been involved recently concerning a dispute on a project where post-practical completion, the building was sold. The employer nevertheless said that there were defects in the works and instructed the contractor not to carry out those works. What they then did was took an adjudication for what they said were the costs of rectification for those defects. And the adjudicator, in my view, did not do a particularly good job. He decided that the alleged defects were not particularized. He decided that the values of those defects were not particularized. And on such basis, he could not decide what was the value to be withheld or could be claimed by the employer. But what he did say was that he decided that the employer had sold the building for less than they had hoped, and this was because of the defects in the works. And therefore, he decided the employer was entitled to £450,000. In other words, he said that I couldn't assess what the defects were, he couldn't value the defects, but he decided there were defects, and therefore the employer could get £450,000, which was the difference they had said between what they had hoped to sell the building and what they actually sold the building. In my view, respectfully, that was a shocking decision. I was approached thereafter and said, was there anything I could do? And I pointed out that I thought there was another dispute. The dispute was that they, as the employer, had found us the opportunity to rectify the defects, and that represented a breach. And that our losses were the £450,000 the first adjudicator had just awarded. Because in my view, but for their refusal to allow us to carry out the works, we would not have incurred this loss, and it wouldn't have cost us anything to carry out those defects because it was our own resources. And we won. We got all the money back. And it therefore points out the importance of identifying what is the nature of the dispute and, being the referring party, identifying exactly the scope of the dispute sought to be referred. And that's the nature of the dispute that I've just dealt with. When I'm an adjudicator, one of the biggest problems I have is understanding what is being asked from me and what went on. Sometimes I look at the submissions and I am completely lost. I simply don't understand what each party is saying. Or in some cases, I understand what both parties are saying, but they are comparing apples and pears. And that can create some major problems for me. And I recognise it may well cause problems for other adjudicators. So I think it is very important that when you are dealing with a dispute, and particularly when you're dealing with the referral, that you identify what is the point in issue and what is the redress sought. I never say one redress. I tend to have 10, 20 or 30 redresses. And what I effectively do is to create a whole line of thoughts. So let's just deal with payment. I might well seek the following redress. That the contract, this would be an extreme example, that the construction contract provides for payment. That the provisions within the construction for payment include for payments on a monthly basis. That in accordance with the contract, the contractor submitted an application which complied with clause whatever. That the employer failed to issue a payment notice. Next address, that by reason of the failure to issue a payment notice, the contractor's payment application became the notified sum. That the employer failed to issue a pay less notice. That by reason of the failure to issue either a payment or notice or pay less notice, the notified sum became due and payable. That the employer failed to pay the notified sum. That the employer shall pay forthwith and without set off the notified sum. So I broke down what is a fairly simple dispute saying, pay me what I've applied for, into a 10 or 11 separate redresses. And each of those redresses I put as a point of issue and then set down my case. That way it is very clear for the adjudicator to understand what is before him. And what I ideally want the adjudicator to do is in each and every time that when he looks at what I've stated, he says, I agree. I want him to effectively cut and copy my submission and put it in his decision word for word. Because it is so clear and easy, it reflects his reasons. All I want him to do is to say, I agree. If it is in a format that he can't say, I agree, it's a problem. Now, I often see very strange, I should use the term rhetoric. You know, they are rude in submissions put. I just think that's unnecessary. This is a legal process. You want to make it clear, precise, and easy to understand. I understand that the parties may hate each other and particular individuals, but that's not going to help you. Your objective view of an individual is irrelevant to whether something is right or wrong under the contract. So try and keep your submissions clear and precise, and make sure that a person who knows nothing about this job can understand what you're talking about and work out your logic as to how you've got to where you are. We've dealt in some part of the address, sort, points of issue, and the drafting of submissions. The first point that is always raised in nearly all adjudications I see is jurisdiction. We've got two jurisdictional challenges, threshold and internal. So let's just give an example. The contract we've entered into says that the adjudicator shall be Mr. Smith. And despite it saying that the adjudicator will be Mr. Smith, the referring party goes off to the RICS and seeks an appointment of an adjudicator, and a Mr. Silver is appointed. Mr. Silver does not have jurisdiction to deal with that dispute because the contract provides that the adjudicator will be somebody else. And it is only that somebody else who can deal with that dispute, unless that person is either unavailable, died, or otherwise. So what we're showing is that you must refer the dispute to the appropriate person. Another example of a jurisdictional challenge is where you argue that there has been no dispute. So, for example, a party goes to adjudication on the basis it's entitled to an extension of time, but has never submitted an extension of time. Or it could be even more slightly difficult. The referring party issued before commencing the adjudication an extension of time notice in full particulars. The other party doesn't respond, and 4 weeks later they go to adjudication. The responding party, let's just say the employer, says, well, there's no dispute. Under the JCT form, we have 12 weeks in which to consider your entitlement to extension of time. And as of yet, the 12 weeks have yet to elapse, and we haven't finished our consideration. So therefore, there is no dispute, and therefore the adjudicator has no jurisdiction. And that's likely to be right. So that is a threshold jurisdiction where the adjudicator would be required to resign. But there may be an internal jurisdiction. In other words, the adjudicator has jurisdiction, but maybe not on one element. So, for example, the contractor submits a fully detailed extension of time, which is rejected by the employer. The contractor then goes to adjudication on the basis of that extension of time, but suddenly raises 3 new relevant events that have never been considered. Those 3 new relevant events have not been considered, cannot be in dispute, and therefore the adjudicator cannot consider them. But the other parts are fine. As you can see, quite often, it is often the case that there is jurisdictional challenges. And I'm going to give you a particular example that I was involved with, and it's a cited case, and it's Harris Coleman versus Ridgeway. A strange case, and I would recommend you read it. Situation is that Harris Coleman were my client. They'd entered into a contract, or at least that's what they thought, for certain works, had completed late and had levied liquidated damages against them. They'd come to me in order to establish an extension of time. And in seeking to establish whether or not they were entitled to an extension of time, I wanted the contract. This proved far more difficult than either they or I had thought possible. The first thing is that they couldn't find a contract. They found me a number of letters of intent, but not a contract. The next point was that there were various letters of intent, all referring to different forms of contract. And it would seem to me that no contracts had actually been agreed. So the problem was that there had been damages levied, but if there is no contract, there is no right to adjudication. So what did I do? I wrote a very short notice of adjudication. I think it was a page and a half of a referral. And I simply said that the parties entered into a contract and that the employer had wrongfully sought the deduction of liquidated damages. And that it was maintained that the employer had no right to such liquidated damages, and thereby a decision should be issued that the liquidated damages should be released. And that was it. The other side, having received it, then responded, saying how terribly drafted my referral was, that it was woefully inadequate, that there was clearly a contract which they enclosed, and that the contract had clearly not finished by the time, and hence damages were levied. I then responded and advised them that if they looked, that the contract they'd produced had never been signed or indeed ever been issued to the contractor, and that indeed the letters of intent referred to a proposed different form, and indeed in their own correspondence they referred to yet a different form. and that the contract they'd actually issued saying was in place had not even been published when the contract had been arguably entered into. The other side, faced with this argument, now raised jurisdictional challenges. They said that the problems with the contract had all arisen because the particular building had gone up in a fire, and therefore they had no copies of the contract, and that they just printed off the version that he had issued in the adjudication. That they therefore accepted that if what we said was right, there was no contract, and therefore there was no right to go to adjudication. But the problem was, it was all too late, because first of all, they hadn't raised that challenge in the response, and they'd actually admitted in the response that there was a contract in place. So they now were in the adjudication, and so the court decided. The consequence was then that they'd now admitted there was in fact no contract, no completion date, and hence no right for liquidated damages. So therefore, they were forced to release all the damages held. I'm next going to deal one is the payment issue, and particularly smash and grabs and jurisdictional issues concerning that. One of the key cases is Pace and Springle versus Harding, which is again a case that I was involved in. Situation is that they contacted me, having been recommended to me by the RICS. What had happened is they'd been involved in an adjudication previously and had lost. Situation was they'd entered into contract with a contractor who had constructed a couple of houses at the back of their plot of land. They and the contractor, however, had fallen out, and the contractor had sought to terminate the contract under the terms of the contract. He had also issued an application for payment. The employer, Pace and Springle, had not issued any notices, and therefore the contractor argued that he was entitled to the amount he had applied for and that the contract had indeed terminated. And they went off to adjudication, and Pace and Springle lost. They came to me thereafter and said, what can we do? And this is all to do with whether there is a different dispute and whether the adjudicator can have jurisdiction to decide that dispute. My advice to them was that there was a difference between an amount that was due because of a failure to issue a payment or a payless notice, a smash and grab adjudication, and an adjudication on its merits, as in what is the contractor actually entitled on the basis of the works that were completed. We went on this second dispute that the contractor was required, or the amount decided as due based upon a smash and grab was not reflected in the value of the works actually undertaken. The contractor ran a jurisdictional challenge and said, you cannot proceed with this adjudication in the first instance because it is the same dispute. And second of all, because the employer has not complied with the first adjudication, in that he hasn't paid the amount that has been decided due. The court considered this and said, on the second point, the adjudication could not continue whilst monies were outstanding and not paid in accordance with the first adjudication. But it was decided that it was a different dispute. So my client, the employer, paid the money of the first decision and then went to the second adjudication. Although it took a lot longer than was anticipated, ultimately we won, and the contractor was required to pay the money back. Since then, there has been a number of cases, and it is settled law that where a contractor is successful on a smash and grab, once that amount has been paid, the employer can then go to adjudication on what is the proper value of the works, and what's more, seek recovery of amounts that it says have been overpaid. What we've got quite often is an adjudication that can be very difficult to follow. We've got a lot of documents that may be issued with the submissions, expert reports, witness statements and everything of that nature. Make sure it is easy to follow. One of the biggest problems I encounter when I'm involved in adjudication is trying to find out what are the parties' positions. The use of an updated Scots Schedule is the best way of dealing with that. A Scots schedule, for those of you who don't know, is a schedule where to the left-hand side, you have everything that the contractor, let's say in this example, says applies, and on the other side is the employers, and then there is a column at the left, far right rather, where the adjudicator reaches his decision. So for example, you might have item number 1, first column, second column, description. This is AI number 3, dated the 3rd of the 6th, 21, and relates to the instruction for the following. Comment, next column. This relates to the value of these items. Contractor says this is an application clause B3, 7 thing of the B accused being 6 meters squared times £12, which equals £72. See Appendix 6. You then have the same basic information on the other side of the employer's assessment, and then it allows me to look at the end and decide which of the parties are right and to provide my comment. And as the submissions are issued through the process of adjudication, you update it, because one of the problems I quite often find is each party will admit certain things. So, the first party starts off claiming 600,000, but accepts, the responding party says, no, it's not 600, it's 300. The other party says, well, okay, we accept it's not 600, it's 540. The other party says, well, okay, I accept it's not 300, but I think it's 320. And you can see it's moving, and that can be very difficult for an adjudicator. So if you produce a Scots schedule, it's going to be much easier to follow. Meetings. Should you request a meeting? Well, my experience is that quite often an adjudicator may be confused, uncertain, and therefore a meeting may be of assistance if he is uncertain of the facts. It is also quite often my experience that parties who believe their cases are strong may well want a meeting. Not always the case, but may want a meeting. And quite often when parties are unconvinced maybe of their case, they may not want a meeting. You need to think about a meeting. But if you are going to have a meeting, you really do not want one of the parties reaching across the table, hitting the party on the opposite side. This is a process that needs to be properly managed, and it is my view that it is best placed with each party being represented. Now, unfortunately, it is my experience that there are errors in adjudicators' decisions. And I'm going to deal with those two issues in relation to two cases I was involved with. The first one is the first one that dealt with slips, which is Bloor versus Bomer and Kirkland. I represented Bomer and Kirkland in this dispute. I was not the adjudicator, nor was I the solicitors who acted in the enforcement. What happened was Bloor had submitted an application for payment. Bomer's had valued and certified a different amount, and there was a dispute. And let's just give some example figures. Let's just say that Bloor had said the account was £1 million. Bomer said it was £500,000 and had paid £500,000, and therefore there was a difference of £500,000. The matter was referred to adjudication, and in the adjudication, when I was representing Bomer, I actually said the true value of the account was only £350,000. Now the point is they'd actually paid 500, but my argument was they were only entitled to 350, and the adjudicator decided that they were only entitled to 450. What he hadn't picked up, therefore, was that Bloor owed us £50,000 because we'd already paid him £500,000. He issued his decision saying that the amount was going to be paid by Bomer's to Bloor's, and we pointed out his error. And he decided that that represented a slip in his decision. The slip was he had not properly calculated the amount previously paid. He had not omitted this amount, and therefore his value was wrong. It was a mathematical error. Bloor was less than happy when the adjudicator amended his decision, but the court said he was able to do so, and you will be aware that now, under the Revised Construction Act and in all contracts, there is provision for the adjudicator to amend slips. I'm now going to deal with another case dealing with slips, which again I was involved with, and this is Osborne versus Atkin Rao, and the situation is not a lot different. I acted for Atkins Rao. Osborne had a claim for a certain amount of money. We'd paid them as Atkins a amount of money, but in the adjudication, we argued that it was a lesser amount. The adjudicator again decided what was to be paid to Osborne, which was less than what we'd actually paid, but he wrongfully failed to calculate or omit the amount previously paid. When we advised him of this slip, however, he refused to amend it. So unlike in Bloor, this time the adjudicator refused to make the change. So Osborne went to enforce those proceedings, and running concurrently with those proceedings, we took a legal action whereby we sought through litigation a decision on what was a discrete piece of law. Namely, in assessing an amount due, should a party omit the amount previously paid? Fairly easy, discrete item to be considered by the courts, and the courts decided in our favour. So there was two judgments. One was that Osborne was entitled to the amount as per the adjudicator's decision, but a second judgment that we were entitled to monies back because the adjudicator had got it wrong, as had been decided through the process of litigation. Going to deal with now defences. It is yet another case that I was involved in, again as acting as representative to one of the parties. The situation was that the subcontractor, it was the subcontractor effectively had carried out a large amount of works and had claimed an extension of time. The employer stroke contractor disputed the claim for extension of time and was of the view that they were entitled to liquidated damages. The employer then took the contractor to adjudication, seeking recovery of those liquidated damages and stating that the contractor was not entitled to any of the extensions of time for which they claimed. The contractor, however, raised new events which it sought to argue entitled to an extension of time, and the adjudicator agreed. The adjudicator said, yes, these new events you've cited do entitle you to an extension of time, and thereby the employer is not entitled to the liquidated damages. The employer shouted foul, saying, jurisdictional challenge, you have considered claims for extensions of time which were never submitted. They were never in dispute. The court disagreed. The court said that whenever a party commences an adjudication, the other party is entitled to raise any defence. Whether they're successful in that defence is a different issue, but they must be given themselves an opportunity to defend themselves. So, for example, if a party is seeking liquidated damages, you must be able to claim an extension of time. And even if you've never raised it, you can nevertheless raise it in the adjudication. Okay, I've covered in outline adjudication. My advice to you is that recognise that adjudication is a very useful process to seek to get resolution on disputes. But it is a legal process and you need to have a clear strategy how to use it. Recognise that in some instances it may be better to use adjudication as a threat as opposed to actually going through the process of adjudication. Be mindful of the adjudication provisions both at the time of entering into the contract and later on when you're seeking to go through the process of adjudication. If you're involved in adjudication, be mindful of the nature of qualifications and experience you require of the adjudicator. If you are of the view that this is very legal, then you should, in my view, suggest go after a lawyer as an adjudicator. But obviously I'm somewhat biased. Do consider whether there is benefit of being the referring party or the responding party. Consider what is the nature of dispute you wish to refer. Do consider how wide or how narrow you want that adjudication to be. When putting together your submissions, make sure that they are properly pleaded, easily understood by somebody who knows nothing about the job or the dispute. Set down clearly what you believe to be the points of issue and the redress sought. Before going to adjudication, do make sure that a dispute is crystallised and that there are not going to be any jurisdictional challenges, be them threshold, in other words, whether the adjudicator can decide the matter at all, or internal, where it just relates to elements of the dispute. Make sure your documents and support are clear, properly cross-referenced, and if there are changes in your position during the proceedings, make sure that's easy to pick up. And finally, consider whether it is in the benefit of having a meeting. I hope that's been of use. Julie, are there any questions?
It doesn't appear to, we don't appear to have any questions currently, so that's good. You've obviously explained it in an extremely thorough fashion. As always, as we said earlier, if there is something that someone would like to ask, adjudication can be a little contentious at times, so it may well be that someone wishes to email you directly. That's Richard Silver at silverllp.com. Richard's always happy to look at an email and give you an answer on a query. Okay, thank you very much everyone for attending. Thank you, Richard, for your time as always. What we've got next week is one on Wednesday, which is John Sharp's update on the Brexit effect. That was one he ran earlier in the year, back end of January. He's now updating that to reflect the current situation. If you would like a place on that, please email seminars@silverllp.com. And I would also point out that our dates for September through to November are now available on the website. Please don't hesitate to pop onto there and book. That's it for this evening. So thank you very much, Richard. Thank you everyone for attending. And we hope to see you all again very soon.
Thank you. Bye-bye.